I'd like to thank everybody for coming to this special work session called by the members of Color Caucus, who decided that this would be a good thing to do at our retreat that we had earlier this year. So first off, I'd like the members to introduce themselves. If there's members in the audience, feel free to come on up here and sit on the dais too. I'm Senator Bob Hasegawa. I represent the 11th Legislative District.
Representative Luis Moscoso from the...
This is the house. You gotta push the button.
Representative Luis Moscoso from the 1st Legislative District.
State Senator John McCoy, 38th Legislative District.
State Representative Chris Reichdella, 22nd District, which you are sitting in. Welcome, everyone.
So thank you for coming. I'm just going to do a quick explanation of what this is all about, the objective for this meeting. But first, I'd like to thank some of the folk who really worked hard to try and put this all together and bring it all together so it makes some sense for everybody. A good friend of mine, Cynthia Delastrinos, who is just got a promotion, actually. She is now the administrative manager for all of the Washington State Supreme Court commissions. She's actually a best buddy of my daughter's forever. So it's really, I'm proud to see her, but thank her for the work that she's put in on this. Bob Cooper with the Public Defenders Association. Thanks, Bob, for all your help in coordinating all of this. Adam Hall is the Senate staff person from the Senate Democratic Caucus who has staffed the members of Color Caucus over on the Senate side. Thank you. And my legislative assistant, Chio Saturn. I just want to say that we have some loosey-goosey legislative decorum rules that we're going to try and observe. Sometimes conversations that we're not used to having about race and ethnicity, people get very invested in those. So I will try to keep us as close to the decorum rules as possible. The purpose of this work session, though, is that the members of Color Caucus, if you're not familiar with us, there's very few legislators who actually identify as people of color. The caucus itself has banded together so that we can amplify our voice in the legislative process, and it's been around for a long time before I came to the legislature. And we've been very successful in drawing attention to mostly budgetary items, but often policy issues as well. Senator Kaiser, please join us on the dais. Okay. So we have a legislative agenda. Oftentimes it includes budget issues. You know, we're trying to protect things that have disproportionate impacts on communities and people of color. Things like language. I can't even remember the phrase for it now. But at any rate, the budget issues we are fairly successful with. But when it comes to policy issues, we're not as successful. We had quite a broad policy agenda last session, and it came back, the feedback I got was that there are often many legislators and even the people of the state do not recognize that that racial disparities even exist. I guess maybe coming from the South Seattle area, we live with it all the time. But from a perspective from the rest of the state, there may not be such an awareness. So we thought that if we're going to get people members to actually vote to change policies that will benefit communities of color and bring equity to our system, the members have to first recognize that disparities exist. So the point of this work session and future work sessions, hopefully, is to just shine a light on where these disparities exist, because from many perspectives, from a minority perspective, these disparities exist everywhere throughout society, yet society is really not willing to tackle and take on the issue of racism, institutionalized racism, racial disparities, ethnic disparities, language barriers, all of these things. So what we wanted to do is we're breaking out a couple of subject areas this time. We're going to talk about disparities within the justice system. So that includes criminal, civil, and juvenile justice systems. That'll be the first hour. The second hour, we're going to talk about racial or ethnic disparities in our community economic development strategies. Future work sessions, hopefully we will talk about disparities in our education system. You know, we always hear about the educational opportunity gap, the school to prison pipeline, those kinds of issues. And we'll be covering other issues as well, hopefully focused around bills that we've already talked about, but that there is not a general awareness for a need for these bills. So that's the point of this session, is to shine a light and have these conversations out in the open about racial disparities and institutional barriers for people of color and inequities in the system. So with that, first off, I would ask for staff to give a presentation on several of the bills that we've identified from the last legislative session that are still in play. The agenda is being handed out now. But let me see. The three bills are Senate Bill 5752, which is a racial impact statement bill. House Bill 1390, which concerns legal financial obligations. It's a Representative Goodman bill. House Bill 1701, formerly known as Ban the Box, but more recently known as the Fair Chance Act, sponsored by Representative Moscoso, and Certificates of Restoration of Opportunity, sponsored by Representative Walkinshaw. So could I ask staff to give us just a real brief intro, because this is not an official legislative hearing on the bills themselves, so they're just going to speak very briefly about what the bill does to give you all an idea of what the bills do. And then if you would like to comment on the bills, you're certainly welcome to, but we're not looking for comment specifically on the bills. That the point of the bills are seen as solutions to some of the problems that we're trying to identify. Right now, we're trying to just shine a light on all the disparities. So if staff could please give us a briefing on those bills, whatever order you feel is appropriate.
I think we'll just go ahead and go in the order that's on the agenda.
Okay.
Good morning, members. My name is Sam Brown. I'm staff to the Senate Governmental Operations and Security Committee. I'll brief you very briefly on Senate Bill 5752 involving racial impact statements. That bill is sponsored by Senator Hasegawa. This bill would require that the Caseload Forecast Council, in coordination with legislative committees, OFM, the Department of Social and Health Services, Department of Corrections, Administrative Office of the Courts, the Minority and Justice Commission, the State Institute for Public Policy, and the Sentencing Guidelines Commission, that all those groups develop a process for providing statements for providing racial and ethnic impact of proposed legislation in Washington, sort of similar to a fiscal note. These statements would be prepared upon the request of any legislator, and the lack of an impact statement would not affect the validity of any legislative measure. That bill went through Senate Ways and Means. It didn't go to the Senate for a full floor vote. In Ways and Means, there was an amendment that would direct the Forecast Council to develop recommendations for procedures and tools, enabling them to provide cost-effective impact statements. And it would be, the Ways and Means Amendment limited the bill to specific areas: criminal justice bills, human services, and education bills where the Caseload Forecast Council provides forecasts. Happy to answer any questions you might have.
Any questions of staff? Thank you, Mr. Brown. I've just been handed a note that if we have a little time set aside for our public testimony as well, so if you'd like to testify on and kick in with this conversation, please sign up on a sign-in sheet someplace in the ether over here. Okay. Yeah,
Good
please,
morning.
Go ahead. Thank you.
I'm Edie Adams. I'm nonpartisan staff with the Office of Program Research, and I'm going to provide a brief overview of engrossed second substitute House Bill 1390, which deals with legal financial obligations, or LFOs, that are imposed in a criminal conviction. LFOs consist of victim restitution and numerous other fees, costs, assessments, and penalties associated with the crime and prosecution. I'll touch on the main provisions of the bill as it passed the House. First, the bill addresses the interest rate on LFOs, which is currently 12%. The bill eliminates accrual of interest on non-restitution portions of LFOs as of the effective date of the act, and allows an offender to petition for waiver of non-restitution that accrued prior to the effective date of the act. It does not change the interest that applies to restitution. Second, the bill addresses imposition of costs stemming from the prosecution, such as defense costs, costs of incarceration, and court costs. The bill provides that a court may not impose costs on an offender who is indigent at the time of sentencing. And it allows an offender to request the court to convert unpaid costs to community restitution on a showing of manifest hardship. Third, the bill addresses collection of LFOs by requiring that LFO payments be applied to principal on restitution in all of an offender's cases within a jurisdiction before those payments get applied to non-restitution amounts. And finally, the bill addresses sanctions for failure to pay LFOs by providing that an offender can only be sanctioned for a willful failure to pay, meaning that the offender has the current ability to pay but refuses to do so. And it creates a presumption that an offender who is indigent lacks the current ability to pay. Be happy to answer any questions.
Thank you. Any questions? No. Very good. Thank you.
Good morning. I'm Trudis Tango, nonpartisan staff with the Office of Program Research. I staff the House Labor Committee, and I'm talking about House Bill 1701, Ban the Box, or the Fair Chance Act. As most of you know, over the last few years, a number of states, including California and Oregon, and also cities and counties like Spokane, Seattle, and Pierce County, have enacted Ban the Box policies that restrict employers from inquiring into the arrest or convictions of applicants at certain stages of the hiring process. Under House Bill 1701, as it left the Labor Committee, an employer is prohibited from doing three things. First, the employer may not ask an applicant or otherwise obtain information about the applicant's arrest or convictions until after the employer initially determines that the applicant meets the basic criteria for the job as described in a job description or advertisement. Second, the employer may not advertise for a job in a way that automatically excludes people with arrests or convictions, so they can't post an ad that says no felons. And third, an employer may not implement a policy or practice that automatically or categorically excludes individuals with arrests or convictions from consideration prior to the employer making an initial determination that the applicant is otherwise qualified for the job position. The restrictions do not apply to law enforcement agencies or employers hiring someone who will have unsupervised access to children or vulnerable adults, and to employers, including financial institutions, that are allowed or required under federal or state law to inquire into the arrests or convictions of an applicant. So that would include, for example, school districts and agencies like the Department of Health that look into criminal background of applicants for certain health professions, because those agencies are already allowed under state and federal law to look into criminal history. The remedy under the bill is a civil private cause of action, and damages are presumed to be the cost of the application plus $500. And finally, the bill does not preempt local ordinances or employer policies that provide greater protections to applicants. I'd be happy to answer any questions.
I have a quick question. President Obama just implemented this policy at the federal level, is that right? So is this similar to the policy that he's implemented through executive order at the federal level?
You're right that the president has implemented a policy for federal jobs. I haven't had a chance to compare the two, so I don't exactly know how they're different.
Okay,
but
thanks,
I could
Ms.
find
Tango.
out and get back to you.
Any other questions? Representative Moscoso.
Thank you, Mr. Chair. I think that Bob Cooper will have an answer on the federal thing when if he gets a chance to speak later on. Just thank you.
Okay, thank you. Okay, no more questions on that. Thanks.
Hi, my name is Tim Ford, a nonpartisan staff with Senate Committee Services. I'll be presenting on 1553. This is in gross substitute House Bill 1553, and it relates to certificates of restoration of opportunity. Under current law, public entities, cities, counties, they cannot disqualify an applicant for employment based solely upon a prior felony conviction. They can take it under consideration, but it can't be the sole basis for disqualification. There are some exceptions to that law for an applicant that is say, applying for a job in the treasurer's office and they have a conviction of fraud or embezzlement, and there are other applications that are similar in nature to that. Under engrossed substitute House Bill 1553, it goes broader. It amends the law, and it says that no public entity may disqualify against any type of criminal history as the sole basis. And there are certain eligibility requirements in order to receive this certificate. You go to a superior court, you apply, and if you meet these eligibility requirements, you are entitled to this certificate. There are some exceptions, again, and you have to be compliant with any and all sentencing requirements from your prior criminal history. So if you have legal financial obligations, you have to be up to date with those, and you can't have any pending criminal matters before the court. And you can't have been convicted of a sex offense or a crime with sexual motivation or registered as a sex offender. There are additionally some exemptions for criminal justice agencies may disqualify an individual, or the Washington State Bar Association may disqualify an individual, and also DSHS when it comes to vulnerable adults and foster children, etc. There is a fiscal note on this bill. The bill did pass unanimously from the House and went over to the Senate Law and Justice Committee, where it received a hearing.
Thank you very much.
You're welcome.
And I'd just like to add, are there any questions first? I'd just like to add that thank you to nonpartisan staff from both the House and the Senate for being here and helping support this work session. I really appreciate it. And I know you scrambled to get it together at the last minute, but I appreciate the help. Okay, so thank you for the briefings. Those 4 bills are going to frame the conversation, but they are just there if you want to refer to them. What we want to do is talk about why the bills may be necessary, where these disparities may exist, and what you think may be some of the causes for some of these disparities. So we have 3 panels scheduled here. The first panel, we're very honored to have Supreme Court Justice Mary Yu with us. If you wouldn't mind coming forward, who in her capacity also co-chairs the Minority and Justice Commission from the Supreme Court. We also have David Borner, who is the chair of the Sentencing Guidelines Commission, and Mr. John Clayton, who's the Assistant Secretary of DSHS and in charge of the Juvenile Rehabilitation Administration. So thank you so much for sharing your expertise with us, and I won't take any more of your time.
Well, good morning, Senator Hasegawa. I'm not quite sure I'm an expert, but I certainly wish you and the other members of this legislature, again, a good morning. I am Mary Yu, a sitting member of the Supreme Court and co-chair of the court's Minority and Justice Commission, and I sincerely thank you for the opportunity to appear and to share our appreciation for your leadership on various proposals. Particularly, we're very supportive of the racial impact statements as part of your decision-making process. We all know that racial disparity exists within our criminal justice system. I think it's undisputed that it exists at every level. We also know that many of us have been working to reduce these disparities and to find where we might reverse the trend of massive incarceration. Our commission has been heavily involved in judicial education to raise awareness within our own branch regarding the impact of certain sentencing practices and the implicit bias that we know also exists. We will continue such efforts, but we also know that we're only one component of a complex criminal justice system. There are many avenues to the moral imperative of seeking racial and economic justice. One concrete strategy, we believe, is to look at the question at a systemic level and at the first instance when legislation affecting the criminal justice system is adopted. Racial impact statements is simply a tool for you to consider and to really explore the unintended consequences that some legislation might have upon minority or economically disadvantaged communities. Our commission, together with the Sentencing Guidelines Commission, strongly supports the adoption and the use of racial impact statements. We think it would provide you, again, with additional information and insight, and perhaps begin to address the real problem that we're all trying to wrestle with today. I'm happy to answer any questions. Again, I'm delighted to be here.
Thank you, Justice Yu. I have a quick question. You participated in a working group last interim in 2014 that actually drafted the language for this bill ultimately, but it was one of the models that we worked off of was the Oregon model, I believe. And do you have any information or insight about how it's working in Oregon?
You know, I don't have any updated information. I must admit that I think that they were struggling to actually get it going because of the real complexity of it all. But I know that there's at least the will and the determination to do so. But we could probably follow up and get you additional information should you like that.
Okay, no, not necessary, but thank you. Let me see, Mr. Borner, please.
Thank you, Senator Hasegawa. David Berner from the Sentencing Guidelines Commission, although I'm here really as an individual. As Justice Yu pointed out, the Commission is a strong advocate for the racial impact statement legislation, and I suspect when we review them, we will be supportive of all of the bills that you're talking about. I think they all go in the right direction. The assignment you gave me was to give my insights on racial and ethnic disparities that exist within the criminal justice system, and that's a 50-year-old perspective. I started as a prosecutor and thus a foot soldier in the war on crime in 1965, and I've been involved one way or another ever since. Obviously, the products of what we call our criminal justice system are disparate. All one has to do is go to a prison or a jail and take a look. There just isn't any dispute about it. The challenge is to understand why that result has occurred, because obviously if you can't diagnose the cause, you can't address it and you can't bring about reforms. I think the important understanding with regard to the criminal justice system is to begin with the idea that it's not a system. There's no one in charge, no agency, no individual. It's a decentralized series of decision makers, all of whose decisions accumulate to the populations that occupy our prisons and jails. It starts with the people and the legislature in terms of determining what crimes, what conduct is going to constitute a crime, and of what severity, what responses we give to it. Then we have the whole enforcement mechanism, law enforcement, which again is very decentralized on local and county level. And the question of where one deploys your enforcement resources, what areas of the community, what crimes to prioritize, and what discretion to exercise in terms of making individual arrests or not making arrests, referring cases to prosecutors, that. I'll give a couple of examples of where detailed analysis has helped to understand the impact of enforcement policies on disparity and has brought about some redress. In King County, in Seattle, some years ago, some studies by researchers out at the University of Washington demonstrated pretty convincingly that the choice by the department of where to deploy its narcotics enforcement efforts, physical areas, Capitol Hill versus the Pike Place Market area was the two areas studied, made an enormous difference in the results. And when one thinks about it, it's obvious. If you enforce in an area that's disproportionately of racial or ethnic minorities, you're going to get more right. Now, it's generally understood that there is no difference based on racial or ethnicity in drug usage. It's a plague across all parts of our society. And yet, we had the study showing that minorities were disproportionately being arrested for drug offenses in Seattle. And why not? that produced a bit of controversy, initially denial, then understanding, and finally a shift in policy and enforcement policies by the department, where they moved resources to different areas. And they also explored, along with the prosecutor's office, diversion programs. King County developed and maintains, as do many counties, aggressive drug court diversion program that again addresses the disparity at that stage, and that's continued with further programs in Seattle. What's happened is that the disparity from drug enforcement has gone down, and it's come down because people understood what was causing it, and then began to address it. But that's just the very front end stage. The whole the issue of prosecutorial discretion, what charges to bring, how many charges in a particular situation, at what level of severity, the use of special allegations, the whole plea bargaining process, what offers to make, what concessions to give or not to give, and all of that are wholly within prosecutors' discretion. And prosecutors, like law enforcement officers, like everyone else, are human beings, and they're the product of the culture that they live in. I don't think we can exclude the defense bar and the resources that we provide to our defense bar and the ability that they have to mount vigorous defenses and to develop alternatives to incarceration and things of that nature. Judges making decisions, again, human beings, on a whole variety of decisions, from the initial decision on custody and bail, whether to require a person to remain in custody, various trial rulings on admissibility of evidence, on jury selection, and all of that. And of course, sentencing within the bounds of the Sentencing Reform Act. Now, back when the Sentencing Guidelines Commission had a research staff, we don't anymore after the budget cuts of recent years. But in the early years when the Sentencing Reform Act was adopted, one of its claims was that it would reduce racial disproportionality in the system. And so the research staff did some studies, and this is back in the early 80s and mid 80s. And what they found was that once you controlled for crime and criminal history, race dropped out. It was no longer a factor. The only place it remained a factor, where there were disparities, was where discretion was totally unregulated. Judges weren't, the guidelines didn't apply, didn't direct in one direction or another, and judges didn't have to give reasons for the decisions they were making. On the exceptional sentence provisions, and the Sentencing Reform Act allows judges to make decisions about mitigated sentences or, in some situations, aggravated sentences by giving reasons which are subject to review on appeal. What the study found then was that race was not a factor. And I think that the reason for that is contained in some recent work that's been, well, not too recent, just been published on unconscious bias and preferences that we all contain. There's a new book that's just been published by a professor at the University of Washington, a psychologist, called Blind Spot: Why Good People Make Biased Decisions. And it's the product of an enormous amount of research on implicit, how human beings go about making decisions, unconscious things, really not consciously thinking, I'm going to view this situation differently. I just do because it's deep within me. If any of you have had the opportunity to take the implicit association test, which is online, it's been taken by now millions of people, you will find that it's eye-opening for all of us, for everybody. You can take a test based on whether you perceive differences based on race, on gender, on age, on a whole host of other factors. When I took it, for example, I was surprised to find that I prefer younger people to old people. And I think the experience is that almost every group finds that their individual preferences reflect the dominant culture. But
So, Mr.
So how do we address
sorry,
that?
I'm going to have to ask you to
wrap it up, I've
'cause
probably
we've got a lot of-
taken way too much time, but then I've been thinking about this for 50 years.
Well, I appreciate your insight. I mean, you've pointed us a lot of good directions here. In conclusion, though, I'm curious if you have any. How do you address arbitrariness in the system? And
I think you have to identify it, and that means you need detailed analysis, research, not in the sense of a study, do we have a problem? We have a problem. The question is, where's it coming from? At what stage of this process is, as for example, the studies in Seattle. I give another short example that comes out of the juvenile system. A very good piece of research some 25 years ago on the King County Juvenile Court showed that and they followed cases each step of the way through, that the most important predictor of eventual incarceration for juveniles was whether they were released to go home with their family after arrest or whether they were retained in juvenile detention. And that was a powerful predictor one way or the other, and it was racially disparate. When the Kitsap County Juvenile Court officials looked at their situation, they found the same pattern. And what they did was to shift social work resources to finding a place for that kid to go home to. Grandparents, uncles and aunts, siblings, and sure enough, what happened was that their incarceration rates went down because when they got the kids into a stable environment, they were able to work. It's that kind of detail, but what that requires is the ability to analyze the data, to look at each situation, and we have in this state some incredibly good resources for that. The Institute for Public Policy, the Caseload Forecast Council are composed of world-class social scientists, and with funding, they can dig into these issues and bring us some issues and then challenge us. All right, now what are you going to do about it? Because there are things that can be done, but you've got to identify the problem in a particular, not just the system's at fault. Of course it is, but that doesn't help us. What helps us
thank
is
you. Yeah, that's
these
what we're trying to
specific
do is
points.
identify what those
and dig into them.
systemic barriers are.
That's right.
Well, thank you for sharing your expertise.
Thank you.
I
Happy
appreciate that. Sir, please.
Senator, member of the committee, I'm John Clayton. I'm Assistant Secretary for Rehabilitation Administration, which actually has all the juvenile justice programs in them. Most of you probably know we have one of the better juvenile justice systems in the nation, and one of the reasons is it's a collaboration between the counties and the state. The way you appropriate money, you actually appropriate money to my department. I in turn do contracts with the county. We put certain provisions in there for the county how to comply with, and then they take the money and actually do a good job of trying to administer programs at the local level. If you look at the juvenile justice system today, what you'll find is that youth in the system, 95% are going to be at the county level. And what we try to do is make sure that they work cases so they don't rise to the level of coming to the state, because if they come to the state, those are the more serious crimes. We have done a good job over time in administering programs. We'll recognize it nationally as been one of the states that does more evidence-based programs than any other state in the nation. You know, other nations even come to us to actually see what we do. So I'm very proud of what we do. On the other hand, I'm not proud of the results we see with youth of color in the system. If you look at youth overall for the last 10 years, we reduced that by 1/2. If you look at youth of color in the system, what you see as the trajectory continues to go up. In other words, the percentage of youth of color in the juvenile justice system continues to go up every year. I looked at some data before I came over. I looked at the data from 2004. Youth of color in the system at that point was 45%. As we speak today, it's
45%?
45%, yes. As we speak today, it's 58%. And that's in a situation where youth of color in the state and the general population in 2004 was 27%, and now it's 34%. So that gives you some idea of the magnitude of the problem. Why I could be proud and say we're doing so great in the juvenile justice system overall and step back and be comfortable with that, I can't, because the reality is we have a long way to go to do a better job of serving families and youth of color in the system. So we asked the question, why does it happen that way? Well, if you look at and critique the system, what you'll find is that in every step in the system, you'll find that there's disparate treatment when it comes to outcomes with youth of color. I start with the school system. The school system, you've heard of the school to prison pipeline, it actually exists. It exists in this state. We have a considerable number of youth where the problem actually starts in the school. It escalates to the point it gets to the court, and sometimes it escalates to the point it gets all the way up to my level. So we have to make sure that we focus more attention on the issue of what happens in the school system. You look at referrals that come into the system overall, what you see is that arrests, referrals, all the different points in the system, you'll see that there's disparate treatment in terms of outcomes for youth of color when it comes to those systems. So we have to do more to invest in that, and we have some efforts on the way. That I can't say that if I talk to you 2 years from now that we actually will solve this problem, but there are some efforts on the way. But we must focus on this, and one of the primary things we need to do is involve communities in this process. We at the table, have a lot of expertise, and we think we have the answers, but I think what we haven't done enough is actually involve communities directly. Number two, we have to look at the recidivism rate. Recidivism rate, 58%. So how can we put in programs that actually, brings youth in the system? We work with them very well, get them stable, but sometimes we send them right back to the same environment that they came from with no support and assistance. Some of you may know, for example, that we have a system in place where a youth comes into our system, they go to the institutions, later they get discharged and they go back to the community. In the past, we used to have a parole officer assigned to 100% of those youth. As we speak today, only 50% of the youth, they go back to the community, actually have a parole officer assigned to them. So therefore, the cycle continues. They go back to the community, they get involved with the same activity they were involved in the past. They come from sometimes very troubled families, so it's understandable that they would actually come back into our system. So we have to invest in those particular issues. Number two, we have to invest in something that's going to result in a better future. The positive youth development aspect. How can we look at them not just in terms of mental health and some of those other things? How can we look at them in terms of making sure that when we bring them in, we give them, number one, we focus on their education, and number two, how can we focus on getting them on the track to develop a skill? And that's what we're trying to do in JR now. We're embarking on a new approach to understand that youth are still going to come into the system, but how can we give them the track in their life regarding reentry, education, and training that we think that will make a difference. I could talk to you about this for a long period of time, but we do have a serious problem in the state. We do have some approaches that I think can make a difference, but we need to do much more.
I appreciate that. Representative Rickdahl?
Thank you. So this is actually for any of you, and I'll just preface it with a little comment. You all in some way sort of alluded to discretion and judgment, which is, I think, something the legislature should always seek to do in our systems and not try to write every prescription from here. But the truth is, this legislature doesn't look like our society. Our judicial system doesn't look like our society. The law enforcement side, the defense bar even, our educators. What are the conscious and strategic things you are doing in your worlds to try to get the professionals in that system to help reflect the society and the folks that they are working with? Because if we all sort of buy into judgment and discretion, which I think is a good thing, you can't continue to have a white population making all that discretion and judgment with all the inherent bias you've talked about in the research. So what are we doing to diversify at every level of those areas?
So I can give you a few things that we've done in juvenile justice in the state. Number one, we recognize clearly that the diversity issue needs to be addressed. It needs to be addressed from two perspectives. Number one, how you manage issues with youth, and then also how you manage issues with your staff. So we actually got a grant from the MacArthur Foundation several years ago, So what we did is went through and did a complete SWOT analysis of our system. And in that analysis, we try to look at our system at all different points. How are we serving youth? Were we actually making decisions that affected youth negatively for youth of color? We also looked at the staffing that we hire and looked at it from two perspectives. Number one, this is a state that has a high percentage of Caucasians, so we need to make sure that we don't excuse anybody in terms of understanding the youth that they work with. So we put them through some cultural competency training, and we also looked at who we hire. We need to hire staff on the front line that actually that work with youth, that look like them, and that can identify with them, and can teach other people about the culture. Those are just a few of the things that we've done. We've also looked at the partnership council that we have that makes decisions to try to make sure that we get more diversity there. And we haven't accomplished all of those goals, but those are just a few things that we've done. And the whole ideal is that diversity and inclusion makes a difference at all different levels, and you have to study the issue. You have to study what works and what approaches work. If you can have an evidence-based program that tells you that if you take certain therapeutic approaches with youth, and we've studied that, and we know how to do that, you can do the same thing in terms of hiring staff and also talking about how you train staff.
Thank you. I'd just like to note that we've been joined by Representative Cindy Ryu. Would you like to say anything?
Yes, thank you so very much. Traffic between Seattle and Shoreline, just that section was difficult. I really do appreciate that in United States, I do like that inefficiency of having a very horizontal system. Even though it might not be efficient, I think it does add to us making sure that we have different eyes, different sets of eyes looking at hopefully every aspect of every child as well as every other person throughout the judiciary system. And I really do appreciate the senator calling this meeting, and I really look forward to learning a lot more today.
Thanks, Representative Ryu.
Senator, may I add one more thing before we step back?
Absolutely, Madam
and that is, the commission is going to continue throughout the year looking at different issues, and we want you to know that we're there to be of service to you as well in any way. One of the things that we will explore, and it's a policy that I invite you to explore with us, is the idea of zero incarceration for juveniles. I don't think that we have stretched enough to really look at alternatives, and we'll be examining that issue, and again, I invite you to do the same.
Thank you. I appreciate that. I'd love to participate with that, so just keep me in the loop. Mr. Clayton, I was just going to mention that you were talking about the school to prison pipeline, and there's this committee called the Educational Opportunity Gap Accountability and Oversight Committee, which came up with a set of recommendations in a bill. What is it? 1541, I believe, was House Bill 1541. A key component of that bill was this whole community involvement piece that you were saying was crucial, the first step. That's another bill that maybe we should have been briefed on, but it had to do, all of these bills, unfortunately, I think a majority of them died in the Senate. So we're having to the Senate is taking responsibility for the lack of progress on these policy issues, but we've tried to address that issue, and any ideas you may have on how we can further that conversation in the Senate so that we can get better consideration for the EOG AOC recommendations would be appreciated.
Okay.
So, thank you. Thank you, our distinguished panel. I appreciate your sharing your expertise and your time with us this morning.